Good morning, everyone. The time is 9:04. My name is Christian Waugh, and I hereby call this March 2023 Citrus County Code Compliance hearing to order. For these hearings, we have a list of items on an agenda that we have to follow. The first item, as you might imagine, is the call to order, but the second is the pledge to the flag. So I would ask you to join me in that right now. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, and the next item on the agenda is to approve the minutes from the February 2023 hearing. I have a copy of those minutes in front of me. Are there any objections to the minutes as currently formulated, or suggestions or modifications? Hearing none, I will approve the minutes.
Staff update: abated and continued cases are listed out front.
All right. Again, good morning, everybody. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master, which is a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing today. When your case is called, I'd ask that you please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence if you wish. During this process, the county attorney's office or myself may have questions of you, the witnesses, or the staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. This is not an appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all of your property, and the county may foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. In each case where I do find a violation, I am required to impose certain costs and explain that fine could be a lien. If I do find a violation, I'll call those the standard provisions of the order, and I'll incorporate them later in the hearing. This is important because I may not give you another date to appear before me. Therefore, you likely will not have another opportunity to plead your case or to explain why you did not comply with county code. The county will continue maintaining its liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I will impose all costs required by county law. If you fix the violation in the time allotted, that cost remains minimal. If you do not, then you'll be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you will be required to return on a certain date. And in the time between hearings, I'll require that you comply with the county law in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Are there any appeals of orders to demolish?
No, sir.
Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you very much.
First case on today's agenda, Theodore Mahiki. Hope I'm pronouncing that right. Case number 217-9360. Code Officer Amy Becker, page 18 of your agenda. Expert on the case, Utilities, Deborah Burns.
Mr. Mahoney, is there any way that you can move over to this microphone? You can stay in your chair as it rolls.
Yeah.
Yeah, you can roll it over. And you can sit, I just
I
need
can
you to
sit?
closer
Okay.
to the microphone.
Okay.
Thank you.
Okay. Thank you. Oh.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. State your name, please, sir.
Theodore J. Mahaki.
Thank you.
Good morning.
Morning.
Good
Sorry.
morning.
Good morning.
I apologize. I have the shingles. This is why I'm hurting.
Well, I understand.
Amy Becker, Citrus County Co-Compliance Division, Co-Compliance Officer. This is case number 217-9360, conflict with Central Sewer Connection, a violation of Chapter 42, Article 5, Section 42-163 of the Citrus County Code of Ordinances. The address is 11640 West Gregory Court, Homosassa, Florida. The property owner is Theodore Mahaki.
Yes, whatever it sounds
Thank
good.
you.
It sounds good.
I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, notice of violation to connect to Central Public Sewer System, the notice of hearing sent to the property owner, and a copy of the signed certified mail return receipt signed for on February 14th, 2023.
It's just Exhibit A.
Just Exhibit A.
Okay. Sir, what I'd like to ask you to do is to look through these documents and let me know if you have any objection to them being evidence in this hearing.
I'm sure she's good at it. I wish this Yeah, whatever it is good. I believe it. You
Okay.
guys always been good to me.
Is there anyone from the public who's going to want to be heard on this case?
You want to be heard on it? That's my nephew. He's living with me there.
Thank you. I've never had shingles, but it doesn't sound good.
It hurts so bad. I've been in the you just go get the shot. You don't want this.
Do you
Oh!
want to submit them?
Get this pulled up. Sorry about that. I apologize.
You want to submit them?
Do I need to?
Yes.
Okay, I'll let you do that on yours then. Okay, so I received this case on January 5th, 2023. I checked Hanson for any permits to connect to the central sewer system and found no permits. On March 14th, I had contact with the owner and he is aware of the violation, and I have expert witness Deborah Burns.
Good morning.
Good morning. Okay, I have the original 365-day letter, the tracking that it was received and signed for, and then we sent out quarterly notices of reminders to connect.
Mm-hmm.
And at the end of the 365, I sent out an additional letter advising of the sewer grant that was available.
When was the initial notice given? I don't know that I have a copy of that.
July 16th of 21,
Okay.
and that was received on July 21st, I believe.
So there's an on-site sewage treatment and disposal system on this property,
Yes.
and now there is, I guess, a sewage.
There's
System that's in
gravity sewer-
range.
Yes.
All right. Let me just review the code section real quick. So did the county provide an initial as well as a final notification under the code section?
The original the 365-day letter?
So in section 42-164 subsection 1, it states, the initial notification shall be sent by certified mail, return receipt requested no less than 1 year prior to the anticipated date on which the utility will become available. So I guess that's what I'm asking
That
about.
was actually sent out after we got final clearance that it's been cleared and people can connect to it. Then we send out the 365-day letter giving them a year from that date.
Okay, so you're saying that you sent that notice out, but it was only after the
It was-
utility was available.
Correct.
So in the code section, in subsection 2, it talks about what's called a final notification, and it says the final notification shall notify all the OSTDS owners within the service area that service is available. And so, okay, I think it contemplates 2 notices, but it sounds like you do it in one.
Well, we did do several.
Oh, okay.
Then we send out, after the initial, we send out quarterly reminder notices, regular mail.
Okay. So Mr. Mihalki, what's going on the property?
Well, here's 2 pictures. I'll show you that I got the gravel that's gonna go into the septic system, because I know I gotta pump it out and bust the septic tank out. But best busted in. I have a hole, where I tore my floor up in the bathroom because I have a crawl space. That's the only way that you can get into it, so I couldn't even finish my bathroom until we get these pipes in. But lately, I've just been in the hospital, back and forth between prostate and the shingles and this big mass they took out of me, and grinding my arthritis out of my knees, but I have somebody's coming down in July, but I just want to see if I can extend it until October, just to be on the safe side, and it will be done. And he's
Okay.
coming in to do it. I tried to apply for that grant that you're talking about. They wanted me to give him $2,700 for this grant. I don't have it. That's what it said on this piece of. I should have brought that paper in. And it said I needed $2,700 to get the.
Have you been in communication with the county about
No.
making the connection?
No. I have a guy that's up in Cleveland. That's what he does.
Okay.
And
So
I'm bringing him
let
down.
me ask the county then, to the best of your knowledge, is this the first time you've heard of this today, the reason why it
Yes.
hasn't been connected? Okay.
Yes.
In order to make the connection, what are the steps?
Well, there was a grant, there is still a grant available,
Okay.
but that was available prior to any code, they can't have any active code cases, otherwise it'll be declined. But the connection fees will be required to be paid up front
See, that's-
instead of the grant.
that must be what you're talking about, that $2,700.
Right. Well, the connection fees for the sewer are approximately $3,045.
That's about what was on. It said 27.
Oh,
something.
excuse me, if you
Okay,
don't
all right, I'm
mind.
sorry. I'm
So,
sorry.
So
I'm asking the steps. So there's a fee of $3,045, and
Correct.
that has to be paid up front.
That will have to be paid up front, and then I have copies of the grant application that he can still qualify for. The grant requirements just require no active code cases, no felony charges, and property taxes are paid in full.
I mean, it's kind of a problem given the current case.
Right. And it was due to expire this month, and the new expiration date is March 31st of '24. So if everything is paid for up front, then each individual connection is still eligible for the $4,000 grant per lot.
Are you saying this case abates if the fee is paid?
After the full connection.
Okay, so that's not an issue. Nothing about the grant is really at issue here
No,
For the
it's
purpose
just
of-
finances.
Okay, so let me get back to the steps. So there's a fee that has to be paid, and after the fee is paid, what next? Does he have to go get an inspection or a permit or something?
He will be required to get a plumber,
plumber.
because we'll need copies of the plumbing permit completed, copies of the septic tank being abandoned from the health department, and just proof of payments to these licensed contractors.
And that's all on him to do.
Correct.
None of that's a county responsibility per se.
No.
How long does that process normally take?
People have done it within, It depends on the plumbers getting out to the property, so it's really hard to put a deadline on it.
Assuming a plumber was available in a month, how long would it on average take?
After all the documents are received, it's, I believe, 4 to 6 weeks through the grant division to reimburse.
Okay. Okay, so what you're talking about with the grant is he may still be eligible to have it reimbursed
Correct.
once it's paid.
They granted
Okay.
an extension for 1 year.
Got it. What I'm trying to figure out is, given that it's admitted there's a violation on the property, how long would be a reasonable amount of time for you to comply before a fine begins to accrue? I assume is the county requesting a daily fine after a certain amount of time period?
Yes.
Okay. Incidentally, what is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Mr. Mahalki, so do you understand everything that was said,
Right.
basically?
My problem is, I spent the last $30,000 I had on taxes that the state put on me. They went back 10 years, saying because I got $3.85 for my house up in Cleveland, that they recharged me another $30,000 down here. I used all my money that I had to pay my taxes, so they didn't sell my house. That's my problem. That's why I didn't have the $2,700. Otherwise, I'd have been more than happy to pay it. But when I seen the $2,700, I just, what am I going to do? Nobody's going to give it to you.
How long do you think you would need in order to start paying the fee that the county talked about and to get the plumber out there?
Well, I got the plumber coming in July. That's when his next
In July?
That's when his vacation he has, where he can come down and give me a hand, and I'll help him. Hopefully, I have these shingles be gone by then. And because like I said, it's a crawl space. You can't. I have to left the door, the floor open so that you can actually get in and out. Otherwise, you still. Yeah, I mean, it's
Is the sewage system working? I mean, is your disposal system
yeah,
working right
yeah.
now?
Oh yeah,
Okay.
yes. I have no problem with it.
Are the plumbers that busy here in Citrus County?
No, my plumber's from Cleveland. I'm bringing him down from Cleveland. That's his next.
All right. Well, here's the thing about a code enforcement case is
Okay.
The law doesn't care where you get your plumber from.
Right.
You understand?
Yeah. Yes, I understand that.
Hence my confusion about waiting till July for a Cleveland plumber.
Well,
That's
his,
confusing.
Well, that's his next day off that he has. The week or 2 weeks that he's going to have.
Why would you use a Cleveland plumber instead of one locally?
Because I can't afford anybody. I don't have no money.
Oh, you're saying this person's willing to come down and do it as
that's
a
what I'm saying.
favor.
Yeah, right. I do
okay.
favors for him. He does favors for me, and that's how
Okay.
everything works out.
Okay.
And I don't have a problem with that. It's just that I used all my money to pay my taxes, and I got $50 into my bank account right now. That's it. I'm on an SSI to where I only get $890 or $980 a month. And the time I pay my taxes, my taxes are $500 a month. I got that alone. So trying to take your phone and whatever else,
Okay.
you really don't have that much money. But I'm willing to get this dissolved. I mean, I could have it done by,
Yeah.
if it's all right, that I could use him from up there. I'll have it done by.
No one knows that. I mean,
Yeah.
I don't know if that person's even licensed or able to.
Well, he works for a plumbing outfit. He's been a man.
Sir, I just don't know, and
Okay,
either
right,
does
I
anyone
understand.
else.
I
No one else
understand.
here knows either. So, it sounds risky to me what you're doing, since it has to comply with all the usual laws. I'm not going to pass judgment on that. What I just want to know, the judgment I have to make is how long to give you to get this thing done before a fine begins.
Can I ask her a question?
I mean,
If it's all right, if I'm
Go
able to
ahead.
borrow the $2,700, I can get this grant.
it's
The grant is gonna be denied at this time because of an active code
Square
case.
one. Okay.
no, you have to pay the fee and then do the work, and then you could get reimbursed.
Right. Yeah, I understand. that
All right.
part, Yeah.
So what I'm going to do is I'm going to find that the property is in violation. It's March now. I'll grant 5 months from today to evade the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and I otherwise incorporate the standard order provisions. But I'm giving you the time that you're requesting.
Thank you.
Good luck.
Yeah, thank you, I really appreciate it. And how do I get a hold of, well, all right.
Next case on today's agenda, Ronald Santagata Jr., case number 217-8342, Code Officer Brandon Norman, page 20 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you state your name for the record, please?
Ronald Santagata.
Thank you.
Good morning, Brandon Norman, Citrus County
I hope
Code
everyone here
Compliance
got their
Officer.
shots. Go ahead.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-8342. Animals as pets, a violation of section 3730B2 of the Citrus County Land Development Code. The address is 6225 South Esmeralda Terrace, Lecanto, Florida 34461. The property owner is Santagata Ronald Jr. I have good service via certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on December 27th, 2022, and a corrective action inspection on January 30th, 2023, and photos of my final inspection on March 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
What animals are we talking about?
There's 3 goats.
3 goats, okay. Sir, what I'd like to ask you to do is take a look at the documents he just mentioned and take your time, but let me know if you have any objection to them being evidence in this hearing. Is this not a residential property?
This is a residential.
It is residential?
Mhm.
Okay. Sir, do you have any objection to these documents?
Yes and no.
Okay, I mean, what objections do you have?
Um,
You have a right to be heard, you know? I want to give you your chance.
kind of I guess an objection to, going around my property, taking photos of our private space.
Do you have any
permission.
objection to the accuracy of the documents?
No, I mean, the pictures are correct.
Okay. So is it a constitutional violation you're alleging, like a privacy, or
Yes.
do you know if he had permission to go on the neighboring properties or not?
They didn't have permission to take pictures of my space, but I know he had permission from that one particular person.
Are you aware of a right that you have that someone can't take photos from a neighboring property of your property?
No, but I would hope that my private backyard space would be respected and not have
Okay.
people peeping Toming from another yard taking photos of my
All right,
private
objection
stuff.
overruled.
Okay.
There is no such law or rule, and in fact, this is part of the issue right now with drones, because it's legal to put a drone up in the air, take photos of everywhere, essentially. Don't need to get permission, but maybe you should have to, but that's not the law. All right, so what's been proposed as exhibits A and B is evidence, and I'm just asking for the record, is there anyone from the public who's going to want to be heard on this case? I don't see any. Please proceed.
On December 27th, 2022, an initial inspection was conducted of the property for unpermitted goats. The property was found to be in violation of the above ordinance. I had a telephone conversation with Mr. Santagata, who informed me that he had 3 goats on his property as pets for his son. I informed Mr. Santagata that this was a violation and that he stated he would not be getting rid of the goats. The property remained in violation at my corrective action inspection on January 30th, 2023, as well as my pre-hearing inspection conducted March 14th, 2023.
Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development, rural residential with mobile homes allowed. RUR does allow, they have 1 acre. So they, with 1 acre in a house, you can have some animals in RUR, so they can have 1 goat.
Okay, so the issue is the number of goats.
Correct. They can have the 1, absolutely.
Okay.
There is a process in the code to ask for more. It's a conditional use with the planning board, Planning and Development Commission. That's one, either remove the extra goats or go through that process and hopefully get approval.
Okay. So I'm looking at section, I just want to walk through it so I understand. Section 3730, subsection A, it says and it does, I think the zoning is mentioned in here. As acreage permits, the number of animals on any such parcels shall not exceed the maximum number of animals per acre. According to the schedule, it lists goats and it basically says 1 per acre.
Correct.
And so because the property is about 1 acre, you're saying 1.
It's 1.09, so yes, they
Yeah,
can have a
okay.
goat.
All right, so I understand that. So what's your perspective on this, Mr. Santagata?
So originally when we got the goats, if you do a quick Google, how many goats per acre in Citrus County, Florida, it says 6, minimum of 3. So we thought that we were within our right to have these. I do have a paper from his doctor of kind of what's going on, why we have them. He's basically nonverbal, doesn't talk, he's severely autistic. The goats have changed everything in his life for the last 2 years that we've had them on that property, and we've had them on the property for 2 years without a single incident or an issue, anyone having a problem. This particular person that allowed the pictures to happen, she has other issues. The sheriffs have been out multiple times because of her. I've had interviews with 15 other neighbors. No one else has a problem. We also live in the neighborhood where we have chickens that roam the streets, turkeys that roam the streets. We have horses, goats, cows within 5 feet of our fence that roam, moo, make noise all day. So we didn't assume that this would ever be an issue. I'm not sure of all the laws and rules, obviously. If we couldn't, I guess.
Wait, you didn't memorize this whole?
I don't even have it.
I actually can't.
Yeah, you do a pretty good job, actually.
I actually could not find the rule that they quoted anywhere. I mean, you Google it, I look in the web. It's almost.
I
impossible.
have had to do that before, and it is a task. It's difficult,
It
but it
is.
is doable. Well, please, I don't want to cut you off, so.
Oh, that's fine. I don't know how to go about keeping these for him because they mean the world to him. His doctor kind of explains it a little bit better over the years of what they have done for him.
Is that a copy of something? Do you want it
Yes.
introduced into evidence?
Please.
I'd like to ask you to show it to the county first, and I'll have them let me know if they have any objections to it being evidence in this hearing.
When we were first made aware of the violation,
So I would just ask that
oh, sorry.
county attorneys will probably want to hear what you have to say, so.
First time.
What is your son's name?
Ronnie.
Now, does this document have any material that you want to remain private and not public information?
No, it's okay.
Okay. Are there any objections to this document being evidence?
No objection.
Okay, then I'll have this introduced as Respondent's Exhibit A, and let me just take a moment to review it. Okay. I read a book a few years ago called Peace, Love, Goats that attested to many of the things that are in this letter as well. So I find it credible. I find it believable. But there's one problem, and that is that the code section doesn't make an allowance for what's in this letter. But did you hear what Ms. Coutu said about the possibility of getting a conditional use permit?
Yes, and that's what I was going to say. I don't know the steps.
Right.
When we were first made aware of this, I called. I spoke with Brandon to see if there was something I could do with him. Then we called code compliance.
Was that the conversation where you said, I'm not getting rid of the goats?
Yeah, because
I'm just
I couldn't do that to him.
right.
I
Well, there's good reasons, and bad reasons to tell a code enforcement officer that they're wrong, or to pound sand. And that's one of the better reasons I've heard. So, but let me turn to the county. How long does that process normally take?
It's one hearing with the planning board. So once he applies, it would be about a month and a half, maybe 2 months tops to have that hearing.
Okay. And if they granted it, it would be immediate.
It would be
I
immediate,
see.
yes.
Okay. What is the county's recommendation on this?
The Citrus County Code Compliance respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So really, it's uncontested that there's a violation. You've got 2 goats basically currently in violation. It's not a big ask of the county, but I don't control them, and we don't know what they'll say once you do go through that process. So what I'll do is I will find that the property's in violation, but I'll grant you 4 months from today to abate the violation. And the reason is that, if the county says no, you may need time to find a place to get 2 of those goats. Or you can just take the fine. But if the property doesn't come into compliance after that time period, then a daily fine of $50 will be imposed. And that fine will be recorded and constitute a lien on your property, and I would otherwise incorporate all the standard order provisions. It's just important for you to find out those steps and keep in touch with the county on what you're doing.
How would I find that guy? I know I spoke to them on the phone. They said they would approve us for like 10, but I don't know who else to speak to or where to go for that.
Yeah, who knows? Maybe you could get 20. But I don't know. I have no idea. That's not a question I can answer. I'm just the code compliance special master, but I do encourage you to speak with the county about it outside of the hearing.
Go in the lobby and just ask for the planner and they'll help you out.
Thank you.
All right. Thank you.
Thank you, sir.
very much. Say goodbye.
Bye.
Next case on today's agenda, Larry Lee and Barbara Merritt Tate, case number 218-1489, Code Officer Amy Becker, page 22 of your agenda.
Ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Barbara Tate.
Thank you.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 218-1489, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner has been previously adjudicated guilty of the same violation at the same location on September 21st, 2022. Case number 216-7045. The violation abated on October 21st, 2022. No fines were imposed. The address is 465 South Thompson Avenue, Lecanto, Florida. The property owner is Larry Lee Tate and Barbara Merritt Tate. I have good service via posting of the property as well as the Lecanto government building, as well as signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, Photos taken during my initial inspection on February 9th, 2023. Photos taken on February 10th showing the posting of the property. Subsequent inspections on February 17th, February 21st, February 28th, March 6th, March 10th, and photos taken on my final inspection on March 14th, 2023. Exhibit B, a copy of the administrative complaint and notice of hearing for the request violation, a copy of the posting affidavit, and a copy of the certified mail return receipt signed for on February 13th. Exhibit C, a copy of the findings of fact and the order acknowledging compliance for the previous violation.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. While we're waiting, sir, I wasn't introduced. Who were you?
I'm the Director of Threat Management. I'm Eric.
Oh, cool. All right. Nice to finally meet you.
Okay, I wasn't aware of the hearing here on September 22nd. I don't,
You didn't attend that hearing.
no.
Okay.
No, sir.
Were you aware that there was a violation at that
I was
time?
aware there was
'Cause you brought it into
a
compliance,
violation,
yeah.
but I thought it was all in compliance and everything was okay. In this case, or.
Well, actually, I just want to make sure that the county attorneys can hear what you say. Is there anyone from the public who's going to want to be heard on this case? Okay, thank you. I'll make sure. I also want to, I didn't mention this in my speech in the beginning, but for everyone's knowledge, these meetings are recorded and they will be posted to YouTube. So take from that what you will. Thank you. All right, so I didn't hear any objections, so I'll have exhibits A, B, and C as evidence. But Ms. Tate, I think you were about to comment on the case, the current case.
Yes.
Okay, usually what I do is I let the county present its case first.
Okay.
And then I want to hear what you have to say, and you have due process rights, so we need to hear what you have to say. Ms. Becker?
On February 9th of 2023, I conducted my initial inspection for accumulation of junk and debris and observed a trailer full of household garbage on the side of the home, a mirror, appliance, and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on March 14th, the property is in compliance.
I'm sorry, what was the last sentence? As of when?
As of March 14th, 2023, the property is in compliance. So in a repeat, we go out numerous times to see. So in actuality, so from March 10th, the property was in compliance. And then I had to check it till here. So from March 10th on, the property's been in compliance.
So what you'll be asking for is a fine from February 9th to March 10th, but
Well-
not one going forward.
What I did was I took it from the fee from the day I posted the property. So on February 10th, I actually posted the property. So the fine would be from February 10th to March 9th.
Okay, and assuming I found and agreed with your evidence that there was a violation, what would your recommendation be?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs to begin on February 10th, 2023, and continue until March 9th, 2023. That would be 28 days at $150, totaling $4,200.
All right, let me take a look through the documents and then I'll turn to you, Ms. Tate, to hear what's going on. Okay, it looks like from the date of the posting on the property, you hustled to clean up the property. It's what it looks like from the photos because there was rapid
We
improvement.
tried as best we can.
Yeah.
I put a roll-off out there, and we pretty quickly, especially the trash, not the junk and that debris, but the household garbage that was out there, which was mostly bagged up. But
How would-
we
how
put
would it
that into
go-
the big roll-off.
How would it go from it being messy and then perfectly cleaned up in October, and then in a period of 3 months, it going back to this?
Well, I found out that there were problems with the tenant.
You have a tenant on the property?
Yes, sir.
Okay.
There were problems within their household that I was not aware of,
Okay.
which I have now been made aware of. One person is in rehab, and the other one, at the time, it's sometime in January, they were incarcerated. And then the other person that was in rehab was left, and I think it really escalated during that time period.
Still, it takes work to put, all that
Yes,
stuff
sir,
on
I
it.
know. It was probably some before that it began. Like during that time period, I believe that he had, there was the bags and everything on the trailer. I think that he had put that in there, getting ready to take it away, and then he was incarcerated. So
Well,
he
I mean-
wasn't able to, and they weren't able, wasn't in they did not contact me at that time.
No, they
So I
wouldn't.
didn't know anything about it until
Yeah.
Ms. Becker informed me.
And so, Ms. Becker, you've had contact with the owner about this.
On February 28th, I spoke with Mrs. Tate, and I've had contact with her throughout.
Was she
Yeah.
cooperative?
Yes.
She didn't tell you to pound sand?
No.
Well, there's good news and bad news, Ms. Tate. The good news is I did just save a bunch of money by switching to Geico for car insurance.
So you're in a good mood.
The bad news is that the law is pretty clear about what happens on a repeat violation, and it may not be your fault personally. It sounds like it's the tenant's fault, but they have now caused there's going to be a fine. And it'll happen again too, if there's a repeat violation later on down the line. Now, before I make any kind of a finding, the public does have a right to be heard. There is someone here in the audience who raised their hand and said they want to be heard on this case. So I'm going to ask him to, I'm sorry, ma'am?
I would like to say further too, though, that the tenant has been talked to again by myself and Ms. Becker, and there will be visits out there. by myself or someone that I know to report to me if anything starts going on again.
There's gonna have to be.
Yes, yes, sir.
all right.
It definitely will happen.
Well, ma'am, I am going to ask this gentleman to come up and be heard, and you may want to make space for him. Sir, could you come up and be sworn?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Kenneth Curry.
Thank you very much.
I live at 394 South Thompson Avenue. I've called 2 different occasions. I've reported this, and Becky's come out on both occasions. A matter of fact, I think there was 3, but I can't be certain. It's totally gotten out of hand because the landlord doesn't seem to show up to see anything over there. This past thing that she's talking about, there were 2 30 cubic yard dumpsters taken out of there in a week's time. She does not see this. She doesn't seem to care. My cats brought home rats when they started cleaning up this place. I've got rats coming into my garage by the cat. It's totally unreal. And the smell in the next door neighbor's house is unbelievable. The place is just a pigsty. And it just seems like nobody cares. Thank you very much.
Thank you, sir. Well, ma'am, you have a right to be heard as well in response to comments.
Okay. Like I said, in the past, I did let things slide a little bit, but I was not aware completely of the situation. I am now, and there is definitely changes, and there were 2 30-yard dumpsters out there. Some of it, a partial bit of it, was for what was in the yard, but then we've also been cleaning up on the inside, and there was some evidence of some rats, and that's been being taken care of.
Well, that's why I was talking about
And
being
it is-
surprised about
it
how
is-
much there actually was in such a
Right.
short amount of time.
And I don't know how he couldn't have seen me because I was over there multiple times this past month or so, picking up and cleaning up and talking to the residents, to the tenant in there. So, like I said, it's bad that it ever got to that point and situation, but it will not again.
All right, so I do find that the property is in violation, and I don't have to grant any time to bring it into compliance because it's been brought into compliance. But I will follow the county's recommendation and assess a fine of $150 per day to run from February 10th to March 9th. What's the total amount on that?
$4,200.
So that will be $4,200. And that could end up being a lien on the property, and the county would have the ability to foreclose on it if not paid within a certain amount of time. I otherwise incorporate other standard order provisions, and I wish you luck.
Thank you.
Thanks.
Next case on today's agenda, Stephen Jagir, case number 217-6854, Code Officer Alan Jonathan, page 15 of your agenda.
I am ready to issue an order in this case. Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I incorporate the evidentiary record from the prior 2 hearings. Mr. Jonathan, do you have anything else to add?
I have further photos from yesterday if you'd like to see those. Basically, the property is the same, if
Okay.
not worse.
I take your representations as accurate. I have
Yes,
no
sir.
reason to believe otherwise. Is there anyone from the public who's going to want to be heard on this case? Okay. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owner once they were advised of the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So, actually, I'll hear first. I'll tell you, I'm going to find a violation. You'll be relieved to know. But I think you have the right to be heard, so sure.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
Barbara Larimer.
Thank you.
Thank you, ma'am.
And I and my son live across the street from him. And every day he puts more junk out. He has blow-up dolls now that he's got one underneath the car that he's looking like it's working on the car, but it's a rubber doll, big one. And then he has one standing up against it. He has privacy fence that's falling down. He's leaving it lay there and he's putting more stuff out. He mows up his mail and then it starts blowing over in my yard, so it has to be cleaned up. And just every day he makes more of a mess and I don't know why. Nobody's bothered him, but it's just getting worse. And the other neighbors know it, but some of them are afraid to even, speak up about it because of him doing something.
Well, you had a good presence at the last hearing, and you made the case well. I've actually changed my mind. I would like to see the photos if you have them.
Sure.
Based on what I heard, I'm interested to see how bad it's gotten. Thank you.
Yes, sir.
Okay, so you're keeping the exhibits consistent
Yes, sir.
in terms of
Yes,
ordering?
sir. Since we've already admitted through C.
Okay, perfect. So what's been proposed as exhibits D and E are evidence. I'm just going to take a brief look here. Okay, there's the doll. All right, so I am going to find that the property is in violation. I will grant the owner 21 days from today to abate the violation. And so part of the reason why the hearing was continued, actually the entire reason why I continued the hearing before, is I was concerned that this was potentially constitutionally protected expression. And there is a case on point from the Southern District of Florida. I'm going to cite it, and it'll be in the order that I've written and will sign and issue today. It's O'Hare, O''Hare v. Town of Gulfstream, 2015 Westlaw 129779393. It's the Southern District of Florida case from the Honorable Judge Middlebrooks, famous for a rocket docket. And what he finds in what he looks at, and he cites a lot of other cases, is that all these kinds of junk laws would be eviscerated if there wasn't a difference between actual junk and art. And what the judge discovers in the law is that the operative issue is the extent to which the junk is transformed. And, you know, in other words, there could be something in a museum that looks like junk, but there has to be some transformative element that actually makes it art. Now, I mean, candidly, you can go to Paris, and I doubt that's true. They'll put something anywhere and, oh, it's art. But for legal purposes, that's the reality. And in looking at the exhibits here, I don't see anything that is transformed from being junk into art. It's not good enough to just put a lawnmower out in the front yard. It's not good enough to put a doll on a old rust heap of a car. So in light of that, and in light of the public input, if the violation is not brought into compliance as ordered, a penalty of $300 per day will be imposed. This fine will be recorded and constituted on the real or personal property of Mr. Jaguar, and I otherwise incorporate the standard order provisions.
Thank you.
Thank you.
Next case on the day's agenda, Ann Xiaoping, case number 217-9662, Code Officer Alan Jonasson, page 6 of your agenda.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 217-9662. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 4492 North Canoe Terrace, Hernando, Florida. Property owner, forgive me if I get this wrong, An Xiaoping? Xiaoping. Thank you. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 12 January 2023, photos from a compliance inspection on 2 February 2023, and photos of my final inspection conducted on 14 March 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who's going to want to be heard on this case? All right, thank you. Thank you. Without objection, what's been proposed as Exhibits A and B is evidence.
On 12 January 2023, I conducted an initial inspection and observed the property to be in violation. On 12 January 2023, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 2 February 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 March 2023, the property remains in violation.
Has it gotten better or worse in your opinion?
Worse.
Okay. You know, I used to live in Hong Kong, and I very rarely get to use my Chinese, and it doesn't look like I'll get to use it today. But there are members of the public who wish to be heard, and I'd like to ask them to come up one at a time, and we'll swear you in, and I'd like to hear your input. It appears there is a violation.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
My name is Richard DeLong.
Thank you, sir.
I live at.
Tell me, I'm sorry, Mr. DeLong, go ahead.
I live at 4508 North Canoe, which is the abutting property. I have been at that location since 1995. So I've been witness to this particular property in a state of degradation since Mr. Ping bought it. And it's an ongoing problem. It always has been since day one.
When did he buy it?
I think it was either 2014 or 2017.
Okay.
And he almost immediately received violations from the county. And it's been abated, and then it's reinstated, and it's abated, and then it's reinstated, and there seems to be no end to it. And at some point in time, I've made numerous attempts to buy the property from him, to clean it up and eliminate the mess. He's unwilling to sell. He keeps his taxes paid so that the county can't foreclose on the taxes. And this particular, the last violation, he was here in, I'm going to say mid-November, and he hired someone to mow the property because it was overgrown. And at that point in time, it wasn't too bad. It wasn't acceptable, but it was good. After he had it mowed, you see the pictures, he started hauling trash in. He removed a refrigerator that was inside the home that had spoiled rotten food in it, and it now sits on the front lawn. And the stench coming from there on a windy day is just unbelievable. And it's to the point now where something's got to happen. It's just gone on too long. The county, for whatever reason, he'll come in and mow it, and they'll say the violation has been abated. But in his mind, he doesn't see it that way. He continues to haul in junk and old tires. I believe he picks those tires up beside the road.
In the violations that you've seen over the years, whether it's going back to 2017 or 2014, what is the most common thing you've seen? Is it a junk violation? Is it overgrown grass? What do you most typically?
Combination. Well, he also has a couple of unregistered vehicles on the property. And the county tells me that they can't do anything about the unregistered vehicles because they cannot verify that they are unregistered. However, they've been sitting in the same spot, and they're turning into junk as well. Some of those vehicles have been in there since day one. And like I say, it's to the point now where, I think you're probably aware, the county is, that they recently removed a couple of buildings on Buffalo Lane that had less than savory people living in them. Our concern is, as neighbors there, that those so-called squatters, they find an abandoned property like this and they move in.
Watch out, this is going to be on YouTube.
Yeah, that's all
Don't
right.
give them ideas.
Let them see it, because I think it should be on YouTube, because this has gone on too long. And if something isn't done, and we're snowbirds, we go back north in April, and if some squatters move in while we're not there, then our property is susceptible to vandalism or whatever, burglary or whatever. And I just hope the county at some point puts an end to this.
All right, thank you.
Mm-hmm.
I do have some questions for the county based on the testimony. Are there prior cases on this property?
So there are, but they
all abated
before they ever came.
There was never a finding of violation.
Absolutely.
Are there any currently pending cases?
No, sir.
Okay.
No, sir.
Was there an overgrown grass case
That
last
I can't
year?
recall.
Okay. Right. Okay.
I assume there was, based
Yeah.
on his testimony.
All right. No reason to doubt it.
But I
Yeah.
did not.
No problem. Is there anyone else from the public who wishes to be heard? Sir?
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth? So
I
help
do.
you God? Please state your name.
R.N. Evans,
Lauren.
R.N.A.U.R.E.N.
Thank you.
I live at 3585 East Squaw Valley Drive. right next door to the property. And I've lived there with my girlfriend. We own the property for about 5 years now. And ever since we moved in, that place has always been run down. Grass overgrown, 7, 8 feet tall. This gentleman would be gone for 2 years at a time. He'd come back, he'd get the grass mowed. That's about it. Then this last time he came in, just like the neighbor said, yes, he got the grass mowed. The day after he got the grass mowed, he had 3 different piles of grass and brush burning in his yard. One of them piles was 10 feet from my house, with a great potential of catching my house on fire. The fire department showed up. I guess they gave him tickets. Fines, I don't know. But the last time he came in, just like the neighbor said, he's dragging in trash, tires, the abandoned vehicles. It's an eyesore. I got wonderful neighbors back here. They come in for a couple months this time of year. They live right across the street. They have to come down here and look at that every single day. It's not right to them. It's not right to me. It's not right to any of the neighbors. It's just, you've seen the pictures. It's really uncalled for. Another issue I'm having with it is I'm constantly having an issue with rats in my house. We all know rats carry disease. We're constantly fighting to keep the rats out of our house. And something needs to be done, because it's just outrageous. I mean, all the neighbors in here that are here today about this are all great people. We all stick together. We look out for each other. We clean. We make sure our area's always neat, clean. And this guy just don't care. He doesn't care about me. He doesn't care about my great neighbors behind me. I really wish something could get done about this. I'm tired of the rats in my house. I'm tired of the eyesore, the stench from the refrigerator, which, if it wasn't full of all that rotten food, who says a kid doesn't go in that refrigerator with the door still on it and get stuck inside? What about that?
Have you ever had any personal contact yourself with the owner?
I've talked to him maybe once, which is a simple wave, how you doing, and that's it. Okay. But it's just something needs to be done.
Sure.
That's all I got.
All right. Thank you, sir. Well, sir, you did already have a chance. Yeah, I'm sorry. Is there anyone else from the public who wishes to be heard? It's now would be your chance. Yes, ma'am? You came all this way.
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your name?
Linda Berna.
Thank you.
I live at 4540 North Canoe Terrace. I'm one of the neighbors as well. One of the reasons why we haven't had communication with this gentleman is when we make an attempt, he tells us he can't speak English. So we've heard him speak English to other people, it's just not us. So it's been very difficult to do any face-to-face communication with him to bring up. And I think my neighbors covered the other concerns well, and we just support that.
Sure.
Thank you.
All right, appreciate it. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $200 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I do find the property in violation. I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $350 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Mr. An. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record, and I otherwise incorporate the other standard order provisions. I'm deviating from the county recommendation for two reasons. One is, actually three reasons. One is the fact that there are prior cases, in other words, may not be prior violations, but prior cases. Number two is the sheer number of people from the public who are willing or wanting to be heard on this indicates, a real concern. Number three is the potential health sanitary issues relating to rats. I mean, anytime, that's valuable evidence when considering how quickly something needs to be dealt with and how strongly. So I appreciate it.
Thank you.
Next case on today's agenda, Charles Gregory and Catherine Baghetti. Case number 217-1962, Code Officer Amy Becker. Experts on the case, Jeff Atkin and Joanna Katu. Page 7 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name for the record, sir.
Charles Baggett.
Thank you.
Good morning.
Morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-1962, after the fact permits, a violation of the Citrus County Code of Ordinances, Chapter 18, Article 1, Section 18-8A. The address is 11589 West Clearwater Court, Homosassa, Florida. The property owner is Charles Gregory Baggett and Catherine Baggett. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on January 4th, 2023. Photos taken on my final inspection on March 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt, signed for on February 10th, 2023.
Yeah, so sir, I'd like to ask you to take a look at these documents and take your time, but let me know if you have any objection to them being evidence in this hearing.
No objections.
Okay. Is there anyone from the public who's going to want to be heard on this case? Nope. Thank you. Thanks.
On January 4th, 2023, I observed a wood deck on the back of the mobile home and concrete in front of the mobile home. Upon arrival back to the office, I checked Hanson. There are no permits for the wood deck or the concrete, which is a clear violation of the ordinance listed above. As of my final inspection on March 14th, still no permits. I have had contact with the owner and he's aware of the violation.
It looks good. What's your problem? I'm joking. I'm joking. I do understand what the problem is. Is there anyone else from the county who wishes to testify?
Joanna Katu, Land Development. It's Coastal Lakes Residential. It's not as simple as getting a permit. It's not meeting waterfront setbacks. I can tell you that he did come in on March 9th and pick up the variance paperwork. It's not a simple matter to prove a hardship for an after-the-fact deck, so that's certainly not a slam dunk, but it is an option available.
Let me make sure I understand. Just give me 1 second. So the setback issue is for the wooden deck?
Correct. And the stairs are actually way too close, so I think he
Oh, I see. I didn't
counter-
realize there was water there. Okay, so
Yeah.
there's on Exhibit A, what you've shown me are photos from a yard that's across the water.
Correct.
Okay. And And you're saying that the steps from the deck are too close?
Too close for even a variance, but I think he talked to our staff, at least a third party heard that he can relocate that. The deck itself also needs a variance, however.
And you're saying it's no slam dunk that the variance
Not
would
after
be
the-
granted?
Right, the hardship for a deck is difficult. Yeah.
Presumably that's because with variances, you don't normally allow them when you've created your own hardship.
True, and also a reasonable use of the land is residential. A deck is not a required use to use the land as residential use. So
Okay.
you've got both.
All right, is that all of your testimony?
That's all mine.
All right, Mr. Atkin, do you have anything that you?
Briefly, Jeffrey Atkins, Assistant Building Official. In researching this property in 2017, there was a permit for a boat lift. And examining the photographic evidence, yes, the deck would require a building permit. Based on the height of the deck, it may require engineering. At this point, the only permits that I see for that site were from 2008 for the replacement of mobile home and accessory structures.
What's the height require? Like, at what point does a height for the deck require engineering?
The walking surface is 30 inches or greater above grade, requires engineering. So if you stay
Well, that looks higher.
29,
Yeah.
correct.
Okay.
You can build your own deck with your own plans.
Okay, it's interesting. All right, well, Mr. Baguette, you've heard what the county has to say. I understand. Do you understand what they're saying about the property?
Yes.
Okay.
I was trying to make my property better, unlike the previous cases you've had here. I did have an architect draw my deck that I built, and an engineer did sign and seal it. So I'm assuming that means it's engineered. I don't know. Or not.
I don't know either, but it basically has to be reviewed by the county.
Right. And I could to see what it is that I needed to do to fix this, and they said it is possible that I could apply for a variance, and that the stairs were a problem. So I did have a sketch drawn of moving the stairs into the deck, to see if that would help me be able to because all I really did was fix what was already there. I didn't know the previous owner didn't pull any permits for it, so I just.
Oh, you're saying when you bought it, the deck was already there.
I just rebuilt it and raised it because it was ground level. I didn't know I figured raising it would be a good thing, not a bad thing. So I was just trying to fix what was already there, making the place better. I didn't intend to.
What about the concrete?
Yeah, the concrete that's there was concreted pavers before, and it was cracking and it looked terrible, and weeds were growing up through it. So I took it out and just put the concrete back instead of, if I'd have known, I'd have put concrete and pavers like it was, but I didn't know but I did add a sidewalk to the side that wasn't there.
Well, and I want to understand, so he needs a permit for that?
He would need a permit for the concrete.
That's what I'm asking.
And then you're getting into as far as how much the lot's covered. So that would be another issue. In other words, concrete is considered
creates
covering
impervious
surface.
But I mean, it's just a permit issue, right? I mean, the county will review
Correct.
the impervious it creates and all that kind of stuff. And there may be conditions on the permit.
To see if it's possible. I mean, that's hypothetical. I don't have an answer to that.
Okay, all right. So in order to bring the property into compliance, he either needs to get the appropriate permits and or variances and comply with whatever conditions of the permits there are, or get rid of the deck as well as the concrete.
Yes.
Okay.
Yes.
Does that make sense? You can either turn back time and take off the offending stuff, right, which in this case would be the concrete as well as the deck, or get those things permitted and approved by the county.
Right. Well, obviously, I would like to get them permitted and keep them because, like I said, I was only trying to improve the property, not violate anything. And I was told by the ladies in permitting that I guess that because the deck is higher than so many inches off the ground, it now counts against me in that impervious percentage. This makes sense to me, but I'm sure they're right. I just, even though it's not
Doesn't make
concrete.
sense to me either, but, yeah.
Either way, that, according to their calculations, with just the concrete, I was at 49%, and I'm allowed to be up to 50. But with the deck, because it now qualifies because of its height, it put me to 56%.
As impervious?
Yeah. I'm sure they know what they're talking about. It's their job, but but not all laws and codes make sense, right? So they
Ms.
said
Katu, I think, wants to say something. I'm not-
I got some bad info there. It has nothing to do with the height of the deck, is whether it's
Okay.
impervious or not. It's
Okay.
whether stormwater can go through it or not.
Yeah. Okay. Right. So, all right. So, Mr. Baguette, here's what I need to figure out is how much time you need to get it into compliance one way or the other. I need to give you a reasonable amount of time to do that. Sounds like you're already on the way. Like
yeah, I'm
you're
on
hustling.
the way. They give me the list of things I need to do. They did mention that it's kind of a long shot, but it's the only shot I've got.
Well, part of it is a long shot, but is 3 months enough time?
I would feel, yes, that would be enough time.
Okay.
I can for sure have applied for the variance and maybe even
Right.
had the hearing by then.
Okay.
I don't know how long that takes, but because they mentioned I needed to do an ISR request or something, I guess because of the percentage change. But the deck is, stormwater does go through the deck, so that's why
Well,
I
that
didn't
would be
understand.
something to take up with the county.
Yeah,
It's really
okay.
not an issue for me. Because there's two different elements here, two different kind of, I think, permitting issues, and a possible variance issue. I'm going to give, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I will adopt the county's proposed findings. The property is in violation. I'll grant 4 months from today to abate the violation. I think it seems to be a reasonable amount of time. You're already hustling to get it done. It's just there's a lot of processes to go through here. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine would be recorded and constitute a lien on your property, and I otherwise incorporate the standard order provisions. And you'll see it, a written order will be issued. Okay?
Thank you.
All right, thanks.
Next case on today's agenda, James Darmiento, case number 216-7792, Code Officer Amy Becker, page 10 of your agenda. Expert on the case, Jeff Atkins.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
My name is James Darmiento. I'm waiting on an architect to finish. That's pretty much all I'm doing.
Well, if you'll give me a moment. Was this case continued?
Negative.
Okay, we've just had other cases together. All right. I just want, normally I let the county present whatever I don't understand the issue
That's
until what
fine,
they
go
tell
ahead.
me, so go ahead.
Amy Becker, Citrus County Code Compliance Officer. This is case number 216-7792, referred to code compliance from licensing after the fact permit violation, a violation of the Citrus County Code of Ordinances, Chapter 18, Article 1, Section 18-8A. The address is 8340 West Amelia Court, Homosassa, Florida. The property owner is James Darmiento. I have good service via signed the certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on January 20th, 2023. Photos taken on my final inspection on March 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on February 6th, 2023.
Sir, if you don't mind taking a look at these and just letting me know if you have any objection to them being evidence.
No, they look good.
Okay. Is there anyone from the public who's going to want to be heard on this case? All right. Probably easiest to give to Ms. Becker. Thanks. I also like to see the photos before I hear it, just so I understand. All right, without objection, what's been proposed as Exhibits A and B are evidence. Okay.
On January 20th, 2023, I observed a metal roof on a mobile home. Arrival back to the office, I checked Hanson and found that there was an old building permit for a metal roof. However, the permit was never issued to the owner, which is a clear violation of the ordinance listed above.
When was that? I mean, when was the permit developed but not issued?
It was applied for on January 7th of 2022.
When you said old, I just wanted to understand,
Old.
like old?
2022.
Or- okay.
As of my final inspection on March 14th, there's still no permits. I have had contact with the owner. He's aware of the violation. And I have an expert witness.
It looks like a pretty roof. Tell me what's wrong with it.
It's a very nice roof. Yes, the after the fact permit was pulled for the metal roof. The permit was denied, requiring an engineered letter for a metal over metal roof due to the age of the mobile home. An engineer's letter is required for the additional structural weight that's imposed on the structure.
Meaning that the roof itself, without being checked, could be too heavy for the structure or a risk to the safety of the structure?
Absolutely. It's a 1971 mobile home, which became, the permit from 2022 was for a 1971 mobile home. Those standards for construction were not adopted by the state of Florida until 1976. Therefore, it's unknown the structural integrity of the mobile home. It didn't originally come with that style of roof. Therefore, we're requesting an engineer's letter to certify the structure as built. And I believe that's what the applicant is waiting for. The permit is currently expired and will require a repurchase once he gets his additional information.
So for the county's purposes, you require an engineer's letter certifying that this thing is good to go.
Yes,
And presumably they would go out and inspect.
we would hope.
And you'd rely on that.
Yes, sir.
All right, Mr. Darmiento, that all makes sense to you?
Yes,
It made sense to me, so.
I understand. I knew all that before I started.
I know
the
you
roof.
did, but I
And
didn't. So
took
that's why it
every-
was important for me
Yeah.
to hear it. And now I definitely want to make sure that we're all on the same page. So where are you at?
Everything he said was true, and I already know about that, and we're on the same page. The problem is the architect is backed up for months, and he's too busy to help me. He probably don't even know that I'm waiting on his help. And besides that, I got him and the guy from CADEC drafting everything up. But right now, I gotta wait on them. There's nothing I can do, and I knew that. The reason why there was no work been done to the house since then is because the last code enforcement officer told me, look, until you get this figured out, you can't do any more work to it. So I haven't been back there. I don't live there. I just bought it to fix it up.
Okay.
I haven't been back there to fix it up until I figure this out. And I'm also working on getting the windows and the siding from the architect as well.
Now, when you say that you need a letter, I mean, would an architect's letter? I mean, that's not enough. That's enough?
Yes.
So an architect can certify this roof?
Or engineer license in the state of Florida.
Okay.
Absolutely.
Okay. Do you have any word from the architect about how long it'll be till they?
The only thing I got from the architect was that he's booked up for at least a couple months and he's busy. That's the
Okay.
only thing he's really said to me.
Okay. Who is the architect?
Thomas H. Williford,
Williford.
and it's got his license number here.
Okay. No, I believe you. I was just trying to see if it was someone I knew. Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's a responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
My concern here with the amount of time is that not just the architect's availability, but the chance that the architect doesn't certify it. I just don't know. Because if the architect didn't, you would need time to replace it and go through the permitting process. And you said no one's living there right now?
No, no one lives there.
Okay. Well, then there's no immediate safety concern. And I'm sorry, what was the fine recommendation from the county?
$50.
Okay. I'll find that the property is in violation and I'll grant 4 months from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. And this fine would be recorded and constitute a lien on Mr. Darmiento's property. I otherwise incorporate standard order provisions.
I understand.
All right, thank you.
All right, do you guys want this paper? All right.
Next case on today's agenda, Doris Steenel, case number 217-7769, Code Officer Brandon Norman, page 21 of your agenda. Experts on the case, Jeff Atkin and Joanna Katu.
Please swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Your name, please?
Doris Steinel.
Thank you.
Good morning.
Good morning.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is case number 2177769, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8, subsection A of the Citrus County Code of Ordinances. The address is 7127 West Grover Cleveland Boulevard, Homosassa, Florida, 34446. Property owner listed as Steinel Doris. I have good service via posting at the property in Lecanto Government Building. And I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during an initial inspection on December 7th, 2022. Photos taken at my compliance inspection on February 8th, 2023. And photos taken at pre-hearing inspection Photos taken at the pre-hearing inspection on March 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit that completed and the picture of the posted notice of hearing.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Okay.
No objections?
No.
Okay. Is there anyone from the public who's going to want to be heard on this case? Okay, I don't see any response. Thank you. What's been proposed as exhibits A and B is evidence?
On December 7th, 2022, an initial inspection was conducted of the property for unpermitted change of occupancy and unpermitted structures on the property. The property was found to be in violation of the above ordinance. I met with two individuals coming to be the business owners of the property at my initial inspection. They explained that when they purchased the property, they had thought they were allowed to establish a business here. I informed them that it was still a residence and they needed to apply for the permits at that time. The property is currently still a residence as of today. The property remained in violation of my corrective action inspection on February 8th, 2023, as well as my pre-hearing inspection conducted March 14th, 2023. I haven't had any further contact with the property owners until yesterday when I did my inspection. I met with the same individuals that I met with during my initial inspection. and explained again the process of which needed to happen and about the hearing that was occurring today.
Do you know how large the property is?
I have an expert.
2 acres.
2 acres? Okay. And what's the zoning? Or you said it's residential? Oh, I'm sorry, yeah.
That's right, Joanna Cantu, Land Development. It is general commercial. The zoning is correct. In 2020, a previous owner applied to convert the residential structure to an office. They had a lot of denials. Most houses aren't constructed commercial purposes, ADA, fire, parking, etc. And then it was withdrawn. So they do need to obtain a permit to upgrade this, or change this, not necessarily upgrade it, but change it to a non-residential use. The zoning's okay. They can do it in zoning, but they need to meet parking and building and fire codes, etc.
Okay, that's what I wasn't understanding. Okay. Mr. Atkin, do you have anything you want to share? Or?
Just mere elaboration. That is everything Joanna has attested to is correct. Just to clarify, the original permit was to add and convert, adding a handicap accessible ramp and driveway apron, which was subsequently withdrawn, and that was by, I want to say from my research, 2 previous landowners who has subsequently sold it, and now the current owner has it. The property appears to be a modular and or mobile home, which would require permits for converted to a change of occupancy to a business.
And you're not saying that all it takes is installing a ramp and a driveway apron at this point. You're saying it needs to undergo county review.
Correct. For a change of occupancy, absolutely.
Okay. All right. Well, that makes more sense to me. I didn't understand looking at the photos. Ms. Steinel, does that make sense?
When I purchased the property, it was purchased as commercial property.
Right.
And no one lives in the residence.
Right.
It is just park car stuff.
Do you understand what they're saying?
Yes.
In other words, no one's denying that it's commercially zoned, or that once the structure on the property is properly permitted for the change.
The structure is just an office. No one lives there.
You may be using it as an office, but it's not permitted to be used as an office. It's right now it's used, or it's only allowed to be used as a residence. Does that make sense?
I guess. Or if it's commercial, but you can use it as a residence, it really doesn't.
Well, I suspect I know why this is. Does the county know why this happened? How this arose? That there's a residential.
It was permitted as a residence. It's not been a commercial site, so we don't have a history of any commercial use there.
Right.
So
And
the structure
it
was permitted residentially.
And in this zoning, is someone allowed to live on the property when it's permitted this way?
If it was a new application, no. General commercial on a major road, you couldn't do a residence, but it's an older structure, so it could be there.
Right.
They could do a caretaker type thing and continue if someone wanted to live there, but it sounds like they're not. So.
Yeah. Does that make sense?
Yes.
All right. How long do you think you would need to go through that permitting process?
However long it takes with permitting.
Have you had any contact with the county?
No, I travel a lot, so I haven't been home, but now we're here, so
Okay.
whatever needs to be done, I'll make sure it's done.
I don't know how long this process takes, even under good circumstances. And does this abate at the time that a permit is issued, or does it abate when the work on the permit is done?
The work on the permit is completed because this is a change of occupancy.
Okay.
There will be a significant amount of engineering just for the site improvements, the stormwater, the access, because the infrastructure is not there.
Stormwater.
They have paving now as a parking area.
It's unknown the impervious surface that is proposed, so there probably will be a site plan and site development plan required too.
So you're saying they may have to dig out a DRA or something like that, or you don't know? Okay.
Right.
Well, it's difficult to know how much time this all will take. I mean, even 6 months sounds like it could. I mean, it may not be done in 6 months if they have to do horizontal work and as well as. Are you in a position to begin this process?
Yes.
Okay.
And it's a paving company?
Yes.
Storage buildings for equipment?
Just for the dump trucks, yes, and the drive. parking.
Any bunker bulk storage for materials, lime rock, asphalt,
No,
concrete?
no, none of that. No.
Yeah, well, yeah, you'd have to permit Conex boxes in your storage structures. I mean, it could be done in 6 months, but that's
I mean, that's really hauling a word these days. All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Does the county have immediate health, safety, sanitary concerns or environmental concerns related to the impervious? Immediate concerns.
Not this time, no.
All right. I will find that the property is a violation, and I will grant 7 months from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will constitute a lien on the property if it's not paid within a certain amount of time. That's all I really have to say. I otherwise incorporate the standard order provisions.
Thank you.
Thanks.
Next case on today's agenda, Kenneth M. Atkins, case number 217-2361, Code Officer Amy Becker, page 5 of your agenda. Expert on the case, Joanna Coutu.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-2361, accessory use or structures, a violation of the Citrus County Land Development Code, Section 3102A. The address is 2237 South Stonebrook Drive, Homosassa, Florida. The property owner is Kenneth M. Atkins. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on January 25th, 2023, and photos taken on my final inspection March 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on February 23rd.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. Thank you. Without objection, what's been proposed as Exhibits A and B is evidence.
On January 25th, 2023, I conducted my initial inspection for LDC violation, accessory uses and structures, and observed 2 structures at the property. On my final inspection on March 14th, 2023, I observed trash next to the structure, and I have expert witness Joanna Coutu.
This is a low-density residential, mobile homes allowed. The property appraiser says they removed their primary structure, which was a mobile, in 2017. So there should not be anything here.
Doesn't look too good either. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings. The property is a violation. The owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed, and I otherwise incorporate standard order provisions.
Next case on today's agenda, G Research and Analysis Limited Liability Company, case number 217-9479, Code Officer Cody McGuire, page 14 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
My name is Serge Plades. I'm a manager for the commercial entity, corporate entity called G Research and Analysis.
Thank you, sir.
If we want to just go through it, redo it.
I issued an order granting a motion for reconsideration. In other words, as a brief recap, my understanding is that on the day before the February hearing, you delivered a motion for a continuance and to dismiss the case, but you provided some paperwork that suggested you had a health procedure, a major health procedure, the actual day of the hearing. And the document was basically seen as spam because it was received from an unknown location. It wasn't sent from, I think, you directly. And now, had I seen that document at the hearing, I would have granted a continuance. And so after the fact, you made it known that that was not appropriate, and you wanted to make sure that you were heard. You raised several due process concerns. And even though you didn't ask for reconsideration per se, that's how I construe what you were actually asking for, is for me to reconsider the order. And so there was evidence presented at the hearing. I think the best way to go about this is to re-present what we went through before so that you do have a chance to be heard on the evidence in the case. Does that make sense?
Yes. The thing is, the reason why I'm here today, I'm responding to the CCE director request to bring the evidences.
Yeah.
And I was talking to different attorneys, and I was asked to submit the documentation because I'm legally cannot make any, even speak about it. Because in case of appeal, the corporation and me cannot be used in this one. So I'm respectfully asking you to use the documentation. We're not asking the decision right now. We accept the decision over the mail. I want to emphasize that your letter, I appreciate it, on March 7th, registered on March 8th, delivered to our email on March 10th. And the evidence that we requested before, it was delivered on March 13th, which is my 60th birthday. Thank you for county for a wonderful birthday gift. So I just want you to read the notes and make a decision over the mail, because this is self-explanatory. Can I submit this one?
Just one moment. I'm interested to, I don't frankly understand what you have in your hands. So whatever it is, I would like you to present it to the county first. I want to get this out of the way, and then I can see what you're talking about.
So I just want to be sure that this document is coming to you.
Yeah. And what I want to know is if the county can review this and let me know if the county has any objection to it. I don't know if it's a motion or evidence or what.
I just want them to be sure that they have a copy of the permit and the open permit from 2018, the
Okay.
open permit, and I want to get, this was a request and some paperwork submitted to the, so I want them to read through. And again, we're requesting as a company to get a representative attorney, and your decision over the mail.
I can address that for you in just a minute. That part of it is easy.
Awesome. Thank you.
So the way I see this document, he's stating that since he's a corporation, he can't represent himself in these
Okay.
proceedings. He needs
Good.
an
Well, that's
attorney,
easy.
And he's requesting 30 days to retain counsel.
Okay, I can deal with that. I want to make sure that I have the document, can review it. Thank you. All right, if you don't mind, what I want to do is read this as a precondition to getting to the county's case. How do I pronounce your last name? Is it Plotitz? Plotitz. Plotitz. Well, Mr. Plotitz, as a first matter, I'm still going through it, but this is the finest document you've submitted so far in any of your cases. This one is the one.
Thank you, the county. If I have orthographic mistakes, I will apologize.
Your legal propositions are mostly correct. Citations are correct. All right, so I've read the motion. Now, there's also two other documents attached to it, and these are from you, right?
That's correct.
And one of the documents appears to be a screenshot of county software.
That's the paper I got today in the morning from the building division permit section.
Okay.
That's a print. It's
Okay.
not my white paper, it's theirs.
And it has to do with, it says, rebuilding truss and roofing, post and beam system, frame and deck, et cetera, in your name, your individual name, and it expires, what is it? What am I looking at?
July 23.
Yeah, July 13th.
That's correct.
Yeah, and then the last page. This is the last page is a handwritten document that you submitted to the county.
That's correct.
This is a copy, though.
That's correct. That's from them.
Okay.
They're from records.
And this is for this case? It's in relation to this case?
That's related to the property itself and
Okay.
the permit.
Okay. All right, then let me first address the legal part of your motion, which you are correct that corporations and companies cannot represent themselves as lawyers In other words, they can't be their own legal counsel in regular court proceedings. And that is why a lot of your cases are correct, that sometimes there are defaults entered against LLCs and corporations that have not been able to find legal representation, because if they're not going to file something that's valid in the court that the court can consider, then the company hasn't been represented and there may be a default. You have case law on withdrawals here, and that's true. So when an attorney withdraws as counsel, they normally get 30, 60 days to find replacement counsel, and if they can't do it, a default might be entered. They're pleading stricken, all kinds of potential sanctions. This is not a court case, though. This is what's called a quasi-judicial proceeding, and having legal counsel is optional. It is not something that is required. So what that means is that principals and managers of LLCs can, in fact, speak on behalf of the LLC in a quasi-judicial proceeding. It happens every day. It'll probably happen later in this hearing, I don't know, but it's very common. However, I do still construe this as a motion to continue the case to find legal counsel. And the problem with that, Mr. Plauditz, candidly, is that you've had months to find legal counsel. And I think in your last motion, you actually said that you had consulted with several attorneys and they hadn't taken the case. I mean, that's what you submitted in one of your prior motions in this case. And that's part of the reason why I wanted to reconsider this, because I wanted to give you an opportunity to be heard based on the evidence itself. I'm going to deny the motion because you are able to speak on behalf of the LLC and present evidence to challenge the court's case, the county's case, if you wish. So
I have an objection because on on point number 8,
okay,
I said I plead fifth and I need an attorney to represent it. And I was told by the Non-Military Bar Association of Florida that any procedure where risk of incarceration, penalty, and lien on the property, and any decision of any court master have to be held on number one. Number two, no attorney was capable to take any evidences not delivered to me by March 13th. That's the evidence I've got. So they did not have any chances to review the evidences. And also, yes, I am supposed to, because there is number one, is a penalty, civil penalty, that's judicial, it doesn't matter. I'm as corporate, I cannot speak, I cannot be participating. That's why I'm here. I'm not participating in any discussion about the case. I'm discussing about the adjournment request and the 30 days of, I will find the counselor. It's not for free. We agreed to pay it. And with the evidence of what I have, with the old burden of the proof, we can see what this postponement of evidences will say. Maybe it will be seen in a different point of light of the law from your point of view, because whatever represented by the county may be quite material different. Is that on the paperwork inside of the material we submitted on the March 13th? That's where we actually write the letter to have an attorney and present us, because without this in the case, I plead fifth, I cannot talk without counsel. With counsel, yes, sure. But again, in case we secure the rights to be protected by the law, protected from public interest, and protected from any form of misunderstanding, misleading, technical mistakes. So we need to be represented by the counsel. It's our rights and violation of our rights. We think it's not really fair, because the county is actually what? Is a political, political subdivision of the county? So we want to be the public safe, we safe, and all decision is made based on the evidences and not on the presentation of evidences. That's what I'm asking the attorney. That's the reason of my delivery, the paperwork, not discussing the case.
that makes sense. So the Fifth Amendment cannot be invoked by a company or an LLC. In other words, business entities don't have the right to invoke the Fifth Amendment. Individuals do. And you're right. In fact, the Fifth Amendment can be invoked even in civil cases because if it can lead to a witness being compelled to provide evidence against her or himself for criminal purposes. So if you believe that there are potential criminal issues with something that has occurred here, you can always, in a traditional proceeding, claim a Fifth Amendment right. However, in civil cases, in regular court cases, when you do that, a finding can be made against the person who takes the invocation, an implication of guilt. And so, for example, if you were being charged by the SEC in a federal case, and you as a witness decided to invoke your Fifth Amendment rights at your deposition and you didn't respond to discovery requests, even though it's a civil case from the SEC, the Securities and Exchange Commission, an implication can still be found that you have admitted the facts that are being asked against you. Even though you haven't admitted to it, there's an implication that can be found based on that. So that's why in my order on the motion for reconsideration, I asked you to find an attorney and to be sure that you did, because I think they would probably be able to capably advise you on the Fifth Amendment issues, or I mean on any legal issues, including Fifth Amendment issues. But because it's not an issue for the company, and I'm going to deny the motion based on the Fifth Amendment invocation, because you have the right to invoke your Fifth Amendment. In other words, you can do that if you choose. It has nothing to do with whether or not the hearing should be continued, because you'll do it 30 days from now anyways. Now, in the what you talked about in terms of evidence, there are no formal discovery transfer rules for quasi-judicial proceedings, and there are none that I know of here. I will issue an administrative order at some point talking about the exchange of evidence ahead of time, but I haven't done it yet, meaning that neither you nor the county has an obligation to provide the evidence to each other ahead of time. What you do have a right to, as a matter of due process, is to review what they have against you today. And that is why I granted the motion for reconsideration, because I believe you do have the right to review what the county's evidence is and to make whatever comment you need about it. I've already reviewed the evidence, but I want to review it again after you have the chance to comment on it. If you don't want to comment on it, if you believe that you're not going to do it based on the Fifth Amendment, that's your right. You don't have to say anything at all. So all motions are denied at this point, and I'll ask the county to present its case.
Cody McGuire, Citrus County Code Compliance Officer. This is a repeat violation, initially observed on January 9th, 2023. The address of the violation is 9632 West Plantation Lane, Crystal River, Florida, 34429. Case number 217-6879, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinance. The property owner, G Research and Analysis Limited Company, has been previously found guilty of the same violation at the same location on October 13th, 2021. Case number 215-2573 with $0 in imposed fines. That violation was abated on March 22nd, 2022. I have good service posting on property and posting at
2023? Did
2022.
You say 2022? Okay.
I'm sorry. Good service posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, finding of facts and order acknowledging compliance from previous case number 215-2573. Exhibit B, photos I took during my initial inspection for the repeat violation on January 9th, 2023, and photos I took during my follow-up inspections on January 17th, the 20th, the 27th, February 1st, 3rd, 8th, and 10th, and photos from my final inspection from February 14th. Exhibit C, a copy of the notice of violation and hearing sent to G Research and Analysis Limited Company, a copy of the posting affidavit I have completed, and photos of the posting of the property.
Okay. Mr. Plauditz, you have the right to look at these documents and let me know if you have any objection to them being evidence in this hearing.
With due respect to the court and administrative procedure, I am a manager for the company. I have no rights to represent the corporation at any type of anything. I am not in a position to review the case. I plead fifth. And with advice of different attorneys, I will not speak on the case. The attorney would.
Is there anyone from the public who wishes to be heard on this case? Without objection, what's been proposed as Exhibits A, B, and C as evidence. I would like to review the documents. Unless the attorney wants to.
I'm sorry.
Now, this case, it's already been brought into compliance, I believe. Okay. Is everything that you've presented to me already in evidence in this case?
We have, I have compliance photos as well.
I know it's in compliance, so that's fine. I mean, I signed the order based on the affidavit. Okay, I remember these photos. So are these, is everything you've given me already in evidence?
Yes, sir.
Okay. All right, so Mr. Plauditz, are you going to continue to invoke your I mean, I'm not making a statement about whether you have Fifth Amendment rights or not here, but are you going to continue to invoke Fifth Amendment rights in response to any question I ask?
Completely interferes with the three-prong system which was asking for, so in the case, I still that's
Okay, then I won't ask any other questions. And I find no basis to revisit or vacate prior orders in this case. The evidence is unrebutted. And I would also add that even if we had continued the case to today, based on the evidence, the fine would still be exactly the same because it was a prior violation. Therefore, I would have found that there was a $300 a day from the date of the violation all the way through the date of compliance. And what happened based on the February hearing is there was an order for all the prior days and then the day going forward, and the fine amount was the same. Therefore, there's been no prejudice to Mr. Plauditz, and the order will stand. All right. Thank you.
Thank you. Next case on today's agenda, Edith M. Munch, case number 217-8685, Code Officer Brandon Norman, page 19 of your agenda.
Hello again. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-8685, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address...
And I'm sorry. Oh, gosh. When I said implication, I meant adverse inference on the last case. But anyways, go ahead. Sorry.
Tracking.
Tired.
The address is 1102 West Noble Street, Lecanto, Florida 34461. The property owner listed is Much Edith M. I have good service via certified mail return receipt, and I would like to authenticate the following documents request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on December 27th, 2022, and my corrective action inspection on February 1st, 2023, and photos of my final inspection on March 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this case? Okay, thank you.
Looks like a camper. We'll get that one next week. Next month.
Thank you. What's been proposed as Exhibits A and B is evidence.
On December 27th, 2022, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation of the above ordinance. The property has remained in violation at my corrective action inspection on February 1st, 2023, as well as my pre-hearing inspection conducted on March 14th, 2023. I have had no contact with the property owner as of today. The severity of impact of the property has caused for the area is substantial. Residents of the community have complained to me of illegal burning and constant traffic of vehicles bringing in more trash and debris to the property on a daily basis. I have had contact with the agents of Florida Department of Environmental Protection who have conducted their own review and determined that there are several misdemeanor violations present at the property at this time, but they're allowing us to proceed forward with our case to try and gain compliance in the property before taking any action on their part. While the property itself may not have had repeat violations, I have witnessed and interviewed with individuals claiming to reside there, and they have been residents of other problematic properties in the past where we've actually had to demo the residents of the property for slum conditions.
In other words, there was a prior case where there was a slum condition case
There
on
was
this
a slum
property?
condition case in the resident for those residents, and now they've transitioned to this property.
I see. All right. Was the case, did they demolish in that case? Do you know?
It was demolished by the property owner once he got the tenants
okay.
evicted.
Okay.
Let's see.
Do you have anything in writing from the FDEP?
I do have an email, and I can provide that.
No, I just didn't know if that was going to be a part of your record, but that's fine.
It just wasn't as of today.
Okay.
I was just going to testify to it.
No big deal.
Okay. With those individuals claiming to reside there, like I said, they've been a part of other problematic cases for other residents. I've observed no effort on anyone's part of the property to bring this violation into compliance. Every conversation held with anyone encountered at the property has just been passing blame to someone else residing there. So it's several families that appear to be living there. No one's taking accountability for any of the junk and debris that's there.
There's several families living in that one structure?
So I do have another case for that property for RV occupancy. So there's a family that's in the RV, and then there's two other families that are living in that other mobile home at this time.
Okay.
That was just found out at my last inspection. So.
Are there kids?
I haven't observed any kids on the property. No. There's some serious health concerns there for sure.
Okay. And I definitely am going to hear from the public, but I would like to know the county's recommendation ahead of time.
Mm-hmm. The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $200 per day along with the administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. I sure would like to hear from the persons who've shown up today and want to be heard. If you would come up one at a time and be sworn. Whoever wants to come up and talk to me.
One at a time, you say?
Yes, sir.
Good morning, ma'am. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Can you please state your name?
Carla Wren.
Thank you.
Good morning, ma'am.
Good morning. I'd like to say first that I'm speaking, in order to keep the foot traffic down from my daughter, myself, my husband, and my son, who were all property owners in that immediate area.
Okay.
The problem started in October, and it is not resolved at this point. And when I say problems, there's multiple parts to that puzzle. The things that I focus on are that there was a wall of tires, literally a wall of tires against the back of the property, and there is a motor home that is occupied, and I see people come and go and lights sometimes, so I believe it's occupied by humans. There is a boat that is full of junk that is a mosquito haven, and there is...
I imagine the tires would be too.
I'm sorry?
I imagine the tires would be as well.
Oh, yeah, that was my concern about the tires. And, you know, it's just, the yard is full of junk. The mobile home is apparently leaking. It has a bright colored, multicolored tarp over it. So, you know, I even wonder about that. Everybody needs a place to live, but it needs to be structurally sound. And I don't know that that is, and that's not really, I'm not here for that. I am concerned about mosquitoes and health issues, and with all of that junk in the yard that had been burned, but the burning has stopped, it's a health issue to me. There's also kind of a human safety issue to me, because at one point, my neighbor, who will talk later, had someone come to his door at 9:30 at night, I think it was, he'll have the details, saying that they woke up, they were passed out in a ditch. They had been taking drugs, given drugs, I'll let him speak to that, and had been money that they had and some other items that they had sometime during the period this person was passed out, had been taken or, you know, gone missing. And there's a lot of traffic that people drive up to the motorhome, or they drive up to the larger mobile home, and they stay 10 or 15 minutes and then they leave. And I have to question what is going on in that 10 or 15 minutes. And I have seen them come and go from both places. If there are illegal activities going on of any sort, I don't feel safe, you know, with people passing out in ditches, whether it's their fault or not, and people constantly coming and going. That, to me, makes me question, are there illegal activities going on?
Well, we are.
The tires were moved into a shed and stored up under the mobile home, the larger of the two structures, I believe. Does the shed leak? Is there condensation? Is there going to be water in those tires? Are they going to stay dry under the house? Are they still going to be collecting water and mosquitoes? And I was there in mosquito season last year. It's rough. and you know, I can't say the mosquitoes are coming from there.
Right. I mean, we signed up for that in Florida, but certainly everyone knows that things like tires catch water and are havens for mosquitoes. Yeah. So.
And junk in the yard.
Sure. Right.
And I don't know if it matters or not to comment on the fires that were taking place. They've stopped. But I did ask.
I'm not going to consider anything that isn't related to the junk case for today.
Okay.
And there may be other cases that come in front of me in the future. It sounds like based on what Mr. Norman said and what you've said, but I'm only here on the junk case today.
Okay, the junk today.
Yeah.
Okay. And that's, you know, that's the junk issue. Rats, roaches, other rodents, that's my concern, and that's right behind my house.
Well, it sounds like you're not alone in your concerns, either in terms of neighbors, and it sounds like Citrus County's not alone in terms of being a governmental agency that's concerned. It sounds like, I mean, anytime the FDEP shows up, that's bad news for the owners. So
I have a hearing problem. Can I just step to this side so I can hear?
I'll speak louder and into the microphone. How about that? Can you hear me okay?
Yes.
No? Okay. Do you have anything else you want me to know about the case?
I know you said you were here about the junk, but the motorhome has been there and occupied for well over 14 days, which I believe is in violation of code. And also, I question where the septic is being emptied. Is it going into a sewer? And if we're just talking about junk today, that's, you know, I've got other things on my list, but.
Yeah, I mean, if there was testimony about the presence of raw sewage or fecal matter or something like that, there hasn't been so far.
Okay.
You know, that might be different. Maybe it would be part of the.
Got it.
I suspect the county would have other cases with that. But anyways, do you have anything else that you want me to know?
Not at this time.
Okay. All right.
Thank
Thank you, ma'am. If there's anyone else who wants to be heard, yep.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your name, please.
Thomas Lang.
Thank you.
I purchased the property adjacent to the Noble Street address, and I currently live at 1071 West Ryder Court. I moved in there in about March of 2022, and it started right away. There was constantly yelling, screaming, fights. People would tow trailers full of trash and garbage up to the place, offload, and then they would leave. And then consequently, it would get burned there. Now, I didn't purchase this property next to a burning dump so I could smell this stuff. And I ended up kind of watching what's going on and realized what they were doing was against the law. And I started calling the code enforcement people and the police and the fire and anybody that I could get that would pay attention. And then they moved a small house trailer or like a camping trailer in, and there were people living in that. And as far as I know, and I know a little bit about it, there is no septic dump there. On April 17th, it kind of came to a head because early in the morning, I was awakened by I'm sorry. Yeah, April 17th was when there was a man that came out of the house and was screaming at a woman down on the road, cursing and swearing, calling her all kinds of names, referring to women's body parts. Now, I've worked construction most of my life, and I'm no prima donna, but I'm not about to put up with that. And I called the sheriff, and it also happened to be Easter Sunday. And I believe that day there was a man taken away. And all of these dates can be checked. And there were still a lot of vehicles coming and going, and once again, pickup trucks dumping trash and leaving them day and night. But they'd only be there for maybe 10, 15 minutes, and some of them didn't bring anything up.
Do you know who Edith Much is, or Mooch?
I do not.
Okay.
I have never met the woman. I did meet a fellow named, I believe his name was John, when I first went over there. The first time I actually met this fella, and I believe he introduced himself as the owner. I actually went over there because they were working on a pickup truck, and they activated the burglar alarm or the alarm system. Now, in numerous places I've been, if you had a problem and you needed help, one of the things that you could summons it with was you set your car in alarm. That lets your neighbors know that you're having trouble and you need help. So I went over there to see if I could lend some help. It was just a mechanical thing, nothing serious. But that's the first time I met him. I've seen him there numerous times. He comes and goes, but it's never been clear to me who actually lives there or owns it. And there's a lot of vehicles that come and go, and they're only there for like 15 minutes. And because there's a circular pattern to the driveway, these vehicles will come up and around, and they light up the entire backyard where I live, and the lights shine right across the back of my house. So it's hard not to notice. Well, when the cars come and they sit there for 10, 15 minutes at night with their lights on because they don't have any electricity there. So and when there's people walking and around, they've got flashlights or headlamps on, and it just kind of, you would notice it more. And so as things went on, to be fair, they just recently changed the driveway, so you cannot drive it around. You have to come in, back up, and go out the same way. But that's only in the last couple of days. They moved a travel trailer in, and there were people living in it. Once again, there's no septic there. On May 7th at 3:53 a.m., I was awakened by a woman screaming. It's pitch black over there. You can't see anything. I woke up and I called the sheriff.
Well, sir, I do want to be clear. I mean, unfortunately, we're really just here for the junk case.
Okay.
So a lot of what you brought up is relevant. The garbage trucks or the trucks just bringing in garbage and so on. But I mean,
I understand.
Yeah.
And I'll get.
And
to,
what I think
to the point.
I think that
But
a lot
I'm
of your
trying to
sorry,
Okay.
I think that a lot of your other testimony probably is relevant for other cases, and you may have a chance for all that other stuff to be heard. I just want to be clear.
Okay. Okay. So now I had been in touch with the code enforcement people. They told me there was a case pending, and so I started to take note of the garbage, and I started photographing the cars and the pickup trucks. I say cars because cars would tow trailers up there and dump off whatever they had and leave. And then during the night, they would set fire to it and burn it. A lot of times I would not know this because they'd set the fires late at night, and the only thing left was the smoke the next day. And I know this is just about the trash, but I ended up leaving. Oh yes, I went to this fellow named John early in July, and I said, okay, look, what you're doing is against the law. You know it. I know it. If I go to the sheriff, they're gonna summons you. You'll have to pay a fine. That doesn't help anyone. I'm coming to you because I don't want to call the sheriff on you, but I know will. What can we do to straighten this out? He told me he would stop burning. Well, in July, later that month, I ended up going up to Maine to visit my family. I had planned on coming back in a short time. I had some major health problems, and I didn't get back till December 11th. At that time, my neighbors informed me that the fires had never stopped, and the piles of trash had grown three times now. Not only were the piles bigger, but there were more of them and more tires. So I started taking photographs of the different vehicles coming and going, dumping garbage off, trash. Let me clarify that. It wasn't household garbage that you would have food waste with. It seemed to be more just trash and construction debris. On January 29th, I photographed a pickup truck towing a dual wheel trailer, and it emptied both the back of the truck and the trailer twice that day. And I notified the code enforcement that I took pictures of it. And I had pictures of the loaded and the unloaded trailers before, after, and during, and I'd be glad to share it with them. And actually, I've got a lot of pictures that I'll share with this court. It stopped after that. Oh yeah, as my neighbor said, on February 18th, a man came to my front door, rang the doorbell at 9:30 at night, and told me that he had awakened in the ditch across the street from this address, 1102, and that he had met a woman, went and got high with her, and he doesn't remember anything after that. My son was there visiting, so I felt very, very, very safe, and my son, we asked him what he'd like us to do. He asked us, even though he had a phone, but he had no cell service, if we would call the sheriff, which I did. Two sheriffs came, ran him. He wasn't wanted, and then they ended up asking him what he wanted. And he said, well, if you can just get me back to the bus station. He had a valid bus ticket on his phone that showed he had a ticket going to Boston.
Sir, I do just,
Okay.
I gotta keep
Got
it.
it, okay.
I mean, at this point, you've had about 15, 20 minutes, and
Okay.
I am pretty well persuaded about the problem.
Okay.
I'll give you that. But I can only focus on the junk and debris. Is there anything else you have to tell me about the junk and debris on the property that you haven't already?
Only in the last couple days
Yeah.
has there been a concerted effort. The tires got moved. The photographs of the stuff getting dumped off is still there because they couldn't burn it. And they've moved the tires into a shed, which I don't think is at all watertight, and partially under the trailer. And the trailer, I don't think, is even watertight because the roof is covered with tarps that blow around in the wind. I mean, not just one tarp, many tarps. Red, white, blue, green. I'd be glad to show you pictures of it. It looks like a circus tent.
There's other cases that we're going to take
Okay.
care of
Okay.
after this case, so we are aware of the violations that's on the property.
I'm sorry if I'm taking my frustration out on
sir.
the.
Well, that's why I
on the
wanted to
court.
let you speak, because
Yeah.
I can understand what it would be like to be a neighbor for something like this. I've been in your shoes. So I take everything you've said very seriously. But as I also said, I suspect, unfortunately, you'll probably have another opportunity to talk about some of these things at cases in the future, if you want.
Yeah.
But I do have enough evidence to rule today. Okay?
Thank you.
No, thank you. Is there anyone else from the public who wishes to be heard on this case? That covers it? Okay. I've already heard the county's recommendation. I adopt the county's proposed findings of fact. The property is in violation. Based on the concerns, I'm going to grant fewer than 30 days from today to abate the violation, which is my customary practice. I'll grant 21 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $300 per day will be imposed. I deviate from the county's proposal just because of the severity and the sanitary issues that I've heard. I mean, the FDEP being involved, to me, just justifies a higher rate. This fine would be recorded and constitute a lien on the property of, I guess, the owner, and I otherwise incorporate the standard order provisions.
Thank you, sir.
Thank you.
Can I ask a question?
Sure.
Has this property not already had 30 days to comply?
Okay. So, in fact, the case started a while ago. Florida law requires that I give a reasonable amount of time to comply with the order. The hearing's over. Thank you.
Next case is on the agenda. James A. Evans, case number 217-9792 and 218-0137. Code Officer Alan Jonason assigned to the cases, pages 11 and 12 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name for the record?
My name is Corey Colby. James Evans is my father.
Alan Jonason, Citrus County Code Compliance Officer. This is two cases. Case number 217-9792, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 218-0137, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 3541 East Brave Lane, Hernando, Florida. Property owner is Evans James A. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 19 January 2023. Photos from a compliance inspection on 20 February 2023. And photos from my final inspection conducted on 14 March 2023. Exhibit B, copy of the notices of violation, copy of the notices of hearing, and a copy of the signed certified mail receipts.
Are the exhibits the same in each case?
They are not. They're
Okay.
different photographs.
Okay. Well, ma'am, are you a tenant on the property?
Yes, I
Okay.
am the tenant.
All right. Now, would you please take a look at these documents
Yes,
and
sir.
let me know if you have any objection to them being evidence in this hearing?
I know it. I'm trying.
Sure. But take your time and look through things. We want you to have a chance to be heard. If there's one thing we know, you'll have an opportunity to be heard in this hearing.
Yeah, that I'll look right from that, and
I mean, you should see how some of these other counties do it. I mean, they'll
I'm
just,
not even
they'll
there,
just
you know, I'm
stampede
not even- I know
right
what it
over
looks
you.
like.
Oh my gosh, it's crazy.
The special master does? Or
Oh yeah,
Yes.
yeah. Thank you. Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect that there is no response. Okay. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence.
On 19 January 2023, I conducted an initial inspection and observed the property to be in violation. On 19 January 2023, a notice of violation was issued for junkyard conditions and unlicensed vehicles, which is a violation of the ordinance as listed earlier. On 20 February 2023, I conducted a compliance inspection and observed that the property remained in violation. I've not had contact with the property owner, but I have spoken to
His daughter.
Yes, ma'am. And as of my final inspection on 14 March 2023, the property remains in violation.
Well, what's going on, ma'am?
I just need an extension. I'm trying. I've had 4 people say they would come and pull the engine out of the truck for me. It's more sentimental than anything. It's my late husband's truck. The engine's great in it. It would actually run, but somebody T-boned me. So I'm trying. I get things done, and then other things come up, and you know, I'm really only one person, and anybody I ask, they'll say they'll help me, but then they don't come back around.
Right.
So I
How much time do you think you need?
maybe 30 days tops.
Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. I find the property in violation in each case. In each case, you are granted 60 days from today to abate the violation. And in each case, if the violation is not brought into compliance as ordered, a fine of $50 per day will be imposed.
Okay.
And I otherwise incorporate the standard order provisions, but that should be enough time.
Thank
All right, yep.
Thank you.
All right, thank you very much.
Next case is on the agenda, Barbara Chipburn, case number 217-9892 and 217-9895, Code Officer Amy Becker, pages 8 and 9 of your agenda.
Last one, fast one.
Pardon?
Last one, fast one. Just
We've got-
kidding. I know
we've
it's
got-
not, I know, I was
Yeah.
just kidding.
Okay, I'll do them both at the same time.
Thanks.
Okay. Amy Becker, Citrus County Code Compliance Officer. This is case number 217-9895, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Case number 217-9892, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. Address for both violations is 9 East Lemon Street, Beverly Hills, Florida. Property owner for both violations is Barbara Chipburn. I have good service via signed certified mail return receipt for both. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on January 18th, 2023. Photos taken on my final inspection on March 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearings, and a copy of the signed certified mail return receipt, signed for on February 11th, 2023.
Is there anyone from the public who wishes to be heard on either of these cases? I'll let the record reflect there is no response. Is anyone staying for the boat launch hearing? No, you're gonna skip out on that. Oh yeah, okay, you're gonna. Well, strap yourself in. Okay, thank you. Without objection, what's been proposed as exhibits A and B in each case are admitted as evidence.
On January 18th, 2023, I conducted my initial inspection for excessive growth and accumulation of junk and debris. On the junk and debris, I observed clothes, household trash, paper, and other debris, which is a clear violation of the ordinance. as well as excessive accumulation of vegetation. As of my final inspection on March 14, 2023, there's been progress on the debris on the junkyard conditions. I have met with the owner. I spoke with her again on March 14th yesterday. Told her that the trash must be contained where the lid fits securely on. And she's having a relative come in to help her as far as the grass.
Yeah, I mean, the debris. Okay. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assign a fine of $50 per day for each violation, along with administrative costs to be after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owner once they were advised of the violations. And we are also asking that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact and find the property in violation. In each case, the owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, then a penalty of $50 per day will be imposed in each case. I otherwise incorporate all other standard order provisions.
Next case on the day's agenda, Billy Green, case number 216-6867. Code Officer Amy Becker, page 16 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 2166867. Accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 589 North Palm Ridge Avenue, Crystal River, Florida. The property owner is Billy Green. I have a signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on January 13th, 2023. Photos taken on February 1st, 2023 in my corrective action inspection. And photos taken on my final inspection, March 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on February 14th, 2023.
Is there anyone from the public who wants to be heard on this case? I don't see anybody. My understanding of the boat ordinance is that code enforcement also has the ability to issue notices of violation for it. I know, I was just interested that you have the authority. Without objection, what's been proposed as exhibits A and B are evidence.
On January 13th, 2023, I conducted my initial inspection for accumulation of junk and debris, observed auto parts, discarded furniture, construction debris, appliance, toilet, and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on March 14, 2023, there is now a dumpster in front of the property, and the carport, if you can call it that, what was in front of the mobile home has been demolished. I have had contact with Mr. Green. He's aware of the violation.
And what's his response to becoming aware of the violation?
His response is that he sold it and it's no longer his.
Does he live there?
No.
Okay. Do you have any reason to believe that he's not telling the truth?
He went through a company that just sells homes, buys homes. And he sent me a bill of sale proving that he no longer owns the property. But the bill of sale, which I have a copy of, and we can make an exhibit if you choose.
I do want to see it if you have it.
Not a problem.
It's a copy. It's not the original bill of sale.
Affirmative.
I presume.
Well,
is
the
it
problem
recorded?
it's not notarized or anything.
Right. Yeah. Well, then it won't be recorded.
So I called.
Well,
I've already seen it.
Oh, okay.
And there's no witness or
Yeah.
anything.
So I called Mr. Green and I told him, I said, this is not proof. You still own the property.
All right. Well, let's
And
see.
that's the end of that case.
Thanks. I'll admit this as Exhibit C. Do we know if this, I mean, is this like and it's some kind of a mobile home that's been retired? I see that it's together with a 1982 mobile home. So is this just a mobile home that's been retired on the property? Do we know if it's been retired or not?
When you say retired, there's a mobile home there. I mean, somebody's living there. I just don't know who that is because they won't talk to me. So somebody's at the property.
Yeah.
He just stares at me and walks away. I mean, he doesn't say anything to me. So I don't know.
The reason why I ask is because until something is retired onto a lot, like a mobile home, it may still be personal property, and it may be that it can be conveyed by a bill of sale. Now, this document purports to convey lots, not just a mobile home, but lots. It's real property, really should be conveyed by a deed. But the issue there is that there are methods by which deficiencies without witnesses on a deed can be corrected, and an instrument like this may still be valid. But I don't know the statute on that off the top of my head. So unless I can be sure that this is the owner, based on what you've testified, I think we need to continue the hearing. Just because I'm not, I know I've gotten around it before. In other words, with deeds that aren't properly witnessed. And I just don't remember exactly. I mean, so one of them I know is time-based. And that wouldn't apply here. A DocuSign deed probably is not the way to go about it. But there is also equitable title. And if money has transferred, there could be an equitable title issue. So what I'd like to do is take a look at this before I issue an order.
Okay,
So
not a problem.
I'm going to continue the hearing to next month.
And maybe it'll be cleaned up by then.
Yeah, there you go. All right, thank you.
Next case on today's agenda, Kevin M. and Vicky L. Hart, case number 217-9810, Code Officer Amy Becker, page 17 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-9810, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 1 Taft Street, Beverly Hills, Florida. The property owner is Kevin M. Hart and Vicky L. Hart. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A. Photos taken during my initial inspection on January 13th, 2023. Photos taken on January 27th at my corrective action inspection. Photos taken on February 28th showing the posting of the property. And photos taken on my final inspection March 14th, 2023. Exhibit B. A copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? No response.
On January 13th of 2023, I conducted my initial inspection for accumulation of junk and debris and observed discarded furniture, a pile of vegetative matter, appliance, and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on March 14th, 2023, the pile of palm fronds, the tire, the discarded furniture, appliance, and trash remain. I have had contact with the owner, and she's aware of the violation.
How aware?
How aware?
Yeah.
I told her about the violation, and I also told her, if you'll notice in the picture, there's also a truck that came on the property that's now unusable. So now I'd advised her I'd open up 2 new cases, one for a vehicle and one for the lawn. So
Has she indicated a desire to comply?
No.
Has she indicated a desire to not comply?
She has not she really didn't say anything at all, and the tenants on the property won't communicate with me. They just don't acknowledge my existence.
That's the story of my life, really.
Wait till your daughter's a teenager.
So you'll be hearing this again. You'll be hearing more cases
That's a scary thought.
for the vehicle and the lawn. They'll be next month.
Oh, by the way, we found out we're expecting a boy. So yeah, on that note, so I can get ignored by both kids when they're teenagers. Thank you. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and we would also ask that the special master additionally find that it's the responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 30 days from today to abate the violation, and if the violation is not brought into compliance as ordered, a fine of $100 per day will be imposed. Otherwise, incorporate standard order provisions.
Next case on the day's agenda, Thomas C. Tolgren Sr., case number 217-8930, Code Officer Alan Jonasson, page 23 of your agenda.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 217-8930, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 2530 North Lantern Terrace, Hernando, Florida. Property owner is Tolgren Thomas C. Sr. I have good service via signed certified mail return receipt and posting at the Locanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 3 January 2023, photos from a compliance inspection on 2 February 2023, and photos from my final inspection conducted on 14 March 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Is there anyone from the public who wants to be heard on this case? There is no response. Let me tell you something. My daughter started daycare a month ago. Everything every parent ever told us about what happens when that begins is, I mean, that is for real. 4 weeks of constant, this is the best I've been in a month, and I really have to blow my nose. But anyways, it's ugly out there, folks. It's ugly. Without objection, what's been proposed as exhibits A and B are evidence.
May I suggest drink coffee and rub dirt on it? You'll be fine.
Good advice. Good advice.
On 3 January 2023, I conducted my initial inspection and observed the property to be in violation. On 3 January 2023, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation mentioned earlier. On 2 February 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 March 2023, the property remains in violation.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a fine of $100 per day will be imposed.
Thank you.
Thanks.
Next case on the day's agenda, Jessica Sue Kimball Everidge, case number 218-0101, Code Officer Brandon Norman, page 13 of your agenda.
Hello again. Brandon Norman, Citrus County Code Compliance Officer. This is case number 218-0101. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is 4301 East Trail 10, Inverness, Florida, 34452. The property owner listed as Everidge Jessica Sue Kimball. I have good service fee posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during the initial inspection on January 20th, 2023, and my corrective action inspection on February 6th, 2023, and photos of my final inspection on March 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit I completed, as well as the photos of the posted notice of hearing.
Is there anyone from the public who wishes to be heard on this case? No response. Without objection, what's been proposed as Exhibits A and B are evidence.
On January 20th, 2023, an initial inspection was conducted at the property for junk and debris. The property was found to be in violation of the above ordinance. The property remained in violation of my corrective action inspection on February 6th, 2023, as well as my pre-hearing inspection conducted March 14th, 2023. I have had no contact with the property owner. At my pre-hearing inspection, I was approached by someone who identified themselves as her daughter, stating that she was incarcerated at the time. I did have good notice or good service for the initial notice of violation, but not for the notice of hearing, so that would explain.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 30 days from today to abate the violation, and if it is not brought into compliance as ordered, a fine of $50 per day will be imposed.
Thank you.
Thanks.
Next two cases on the agenda, Dennis L. and Mildred G. Wyant, case number 217-46-647 and 217-4648. Pages 20, 24 and 25 of your agenda, Code Officer Brandon Norman.
Hello again. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-4647 and 217-4648. 217-4647 is for accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 2031 of the Citrus County Code of Ordinances. 4648 will be an excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 2061 of the Citrus County Code of Ordinances. The address is 9360 East Briar Court, Inverness, Florida, 34453. The property owner is listed as Wyatt Dennis L. and Wyatt Mildred G. I have good service via certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on October 18th, 2022, and the corrective action inspection on January 25th, 2023, and photos of my final inspection on March 14th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt. Each individual case has their own exhibits.
Okay.
Photos all taken on the same day.
Thank you. Is there anyone from the public who wants to be heard on either of these cases? There is no response. Thank you. What's been proposed as Exhibits A and B in each case are admitted as evidence.
On October 18th, 2022, an initial inspection was conducted of the property for junk and debris and unkept lawn. The property was found to be in violation of the above ordinances. The property remained in violation of my corrective action inspection on January 25th, 2023, as well as my pre-hearing inspection conducted March 14th, 2022. I have had no contact with the property owners.
2023.
Oh, 2023. I apologize. Typo. Thank you. This was kind of a drawn-out case due to the change of ownership, so we had to rescind the notice of violation.
So even though it changed ownership, it's the same, nothing's happened on the property?
That's correct, and I've had good service on notices of violations and notices of
Yeah.
hearings.
Interesting. All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day per violation, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find that it is a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. I adopt the county's proposed findings. The property is found in violation in each case. In each case, the owners are granted 30 days from today to abate the violation. And in each case, if the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed.
Thank you.
All right, does that conclude it?
Yes, sir.
All right, so the time is 12:11. This hearing is adjourned.